YouTube, it's Tone back with another one for you. So this one here is a continuation of the common law abatement. This is a pretty quick book too, so I'm gonna run through this briefly. So I know that your attention span is about 5 minutes or so. We're gonna try to keep it within that time frame. Maybe that's as much time as you have on your break at work, whatever the fucking reason is. But I know that it's a short span from what I see from the analytics. So let's go ahead and get right into this shit. All right. So while I will never succeed in bringing down the current regime in this manner, they're talking about the common law abatement, right? You can't fucking crush them by doing that. There's other ways you can go about doing that, but I don't think anybody's really up for all that. So, right now anyway. And we got people for that anyway. That shit ain't really up to us. You know, we deal with what we have to deal with for ourselves and our family. And we got a military to come take care of these motherfuckers anyway. We're in the middle of doing, mind you. Well, I will never succeed in bringing down the current regime in this manner. At least other folks will see what I'm doing, and some decide along the way that they want to learn this procedure. I contend that if only 10% of the people enforce their right to know the nature and cause of the accusation, that we would most certainly shut down the incessant stream of revenue being fleeced from the people by using these administrative scam artist courts. As far as compelling government interest doctrine, there is clearly matter founded in law, martial rule. The military authority is in the process of returning control to the civil authorities, but has not yet completed the process. I simply do not understand the nature and cause of the accusation with regard to the elements of personal jurisdiction, venue, and the nature of the action until the prosecution properly alleges them. I am therefore unable to enter a plea to the charge until I have had an opportunity to raise a meaningful defense against these elements. I cannot rebut an unstated presumption, right? So we're not going to pretend to know what the fuck these people are talking about. We're going to make them clarify what the fuck that they're even talking about and the cause and nature of the action before even making a fucking determination as to which route that you're going to take. Don't fucking pretend that they even know what the fuck that they're talking about, because I'm sure nobody even asked them. So you fucking ask them and make them say that shit. And as a matter of fact, make them put that shit on paper and fucking sign that shit under the penalty of perjury. Don't let these motherfuckers just start yapping off in the courtroom. Make them put their fucking ass on the line too. You're not going to be the only one in there with skin in the game, right? You guys want to fucking play games? Put your freedom on the line, and I'll put mine on the line, and we'll see who the fuck walks out of here. You know what I'm saying? Come on, cut that shit the fuck up. The courts operate on silent judicial notice of presumption all the time. It is time for this to end. Generally, when you appear, the police officer is not there because he has been instructed to stay home that day. You simply move for a dismissal for lack of prosecution, as the prosecutor cannot testify to the facts, which he has no first-hand knowledge of. They just in there fucking yapping off some bullshit that some other fucking asshole wrote on a piece of paper. Third-party collectors. All different corporations inside that motherfucking building against you. The lawyer, private membership association, plus taking money from the fucking state at the same time, and probably even a fucking state national that they have him fucking playing all the fucking sides. And then they got the judge over here working for a fucking bank, and the prosecutor's working for a whole nother company against you. Third-party collection, unfair debt collection practices, federal crimes, right? On top of mail fraud, they're sending you fucking fraudulent fucking demands like there's somebody special. Get the fuck out of here, bro. So generally, when you appear, the police officer is not there. Why would he show up? Be especially careful of the judge's conduct. He is required by his oath of office to be an impartial trier of fact, not the assistant prosecutor. Have fun, but please do not abuse this procedure, as it may become ineffective because of the abuse. Professor at law Don Quixote. Right? These are all things to keep in mind when you're dealing with these fucking scam artists. Call them out. You got to call them out. So, example of an actual proceeding where abatement occurred. Los Angeles, California, Monday, March 21st, 1994, 1:30 p.m. The clerk, item number 6, case CV, whatever. United States of America versus Randy. Mr. Roth. Good afternoon, Your Honor. Assistant U.S. Attorney General Roth appearing on behalf of the United States. Without America, mind you, right? The United States of America? No, just the United States. And which is a corporation registered in England. And its agency, the Internal Revenue Service. Okay, well, that's another corporation. So these are all offers here. The court, is there any opposition? Mr. Whatever, for the record. The court says yes. Mr. Whatever. My Christian name is Randy Lee, and my family name is whatever it is. The court, all right. So Mr. Whatever his name is, we'll call him Mr. O. That is spelled R, lowercase A-N-D-Y, capital L, lowercase e-e. So he's putting it in his in the Christian appellation, if you will, and that's going to be in the upper and lower case, not the all caps. So he's stating that for the record, that his name is not Randy in all caps, more so than it is the upper and lower case. I have responded to this position because it was found on the door of the place where I take up housekeeping and attempt to create a colorable person under colorable law by the name of capital R-A-N-D-Y, L period, capital O. The artifice, which is the artificial being used here to deceive this honorable court, must be abated as a public nuisance, right? And you can even go ahead and bring in, what the fuck is that form called? A fictitious name form. I forget what it is, but I know I have a video on it if you scroll down, right? And check that out, and definitely file that on the record too. A certificate of what the fuck is it called? A certificate of a fictitious name. And so you sign that. I think it's in the form of an affidavit. Definitely check out the video on that. And I'll just move on. So for the record, Randy Lee and Jesus Christ, advocate and wonderful counselor, are using the right of visitation to exercise the ministerial powers to be heard of this matter. I, Randy Lee, am a native Californian and a man on the land in Los Angeles County, not a resident, which is a commercial term, in the federal judicial district of the Central District of California. My colors and authority is the California bear flag with the gold star. My law is my family Bible, which I have in my hand, in addition to the seal of the people to show my status. I am who I say I am, not who the U.S. attorney says I am. Further, I say it not and stand mute. The court, all right, please take your things off the podium and sit down at your table, Mr. Roth. Do you have any response to this alleged case of mistaken identity? So at this point, I think they're asking the prosecutor if they have anything to say about that shit. So then, here we have the rest of that. So Mr. Roth, well, Your Honor, Mr. O seems to think that if you spell his name in upper and lowercase, it relieves him of his compliance. The court, thank you, Mr. Roth. Please call the next case, sir. Right? So that's the end of that fucking case. And it's all based on a clerical error, which obviously vitiates the fucking case because it's fraudulent in nature, as you cannot be referred to as a commercial entity when you, one, are not one, and two, you were not operating in commerce at the time of whatever the fuck fake ass charge that they decide to bring up, right? So, because they only have jurisdiction over regulating commerce, and that's it. That's as far as it goes. They can't even address a live living person in there. That's why they count on you not knowing who the fuck you are and answering on behalf of a commercial entity as if you are the commercial entity. It doesn't work like that. So, definition: the abatement of an action at law is the overthrowing of the action caused by defendant's pleading some matter of fact tending to impeach the correctness of the writ or declaration. The abatement of a suit in equity is a mere suspicion of all the proceedings therein for a want of proper parties before the court. A plea in abatement is defined to be a plea that, without disputing the justice of the plaintiff's claim, objects to the place, mode, or time of asserting it, and requires that therefore and pro habeas judgment be given to the defendant, leaving it open to renew the suit in another place or form or at another time. So they could bring up the charge in a different form, a different manner, and then you would have to fucking attack it differently at that point. You don't always have to fucking argue with these people. You can just fucking accept the charge for value and return the charge for value and tell them that you're there for settlement and closure and demand that they close the case using your fucking exemption because you are exempt from levy, right? Of course you are. Because a live living man cannot be fucking taxed, but a fucking corporate entity can, right? So you need to know that you are not that, right? And so that's one of the major things that the UCC1 does. Even though a lot of people are really fucking against that, and they with their whole private shit and all that. I'm sure that they don't deal with court much, because when you go into court, you can't even fucking really deal with these people at all. If you're in the private, you're probably gonna end up in dishonor in some way, shape, or form. And so the point of UCC1 is to establish the separation between you, the private living soul, and your corporate fictitious entity, and your security agreement establishes the separation there. So when you go into court, you have the proof in your hand that you already established a separation, which shows, because you can't put a fucking lien on yourself, but you can obviously put it on a fucking fake entity, right? So what is it? So that's really the purpose of that, on top of a lot of other benefits as well. But that's the major one that I think is crucial to understand. So 2B, effective abatement. 1, at law, a effective on principle suit. At law, the abatement of a suit is a complete termination of that particular suit so that it cannot be revived, but it does not determine or defeat plaintiff's cause of action or bar the issuance of a new suit. 7C, pleas and abatement not favored. Pleas and abatement, being dilatory pleas, are not favored either at common law or under the Codes and Practices Act. For this reason, as will be shown in other pleas or answers in abatement must allege that the greatest certainty in every particular ever fact necessary to their sufficiency. No presumption of law, excuse me, no presumption of law or fact are allowed in their favor, but on the contrary, every intendment must be taken against them. Furthermore, matter in abatement must be pleaded at your earliest opportunity if the facts are known before a plea is answer in bar or interposed, or before greatest imprudence or continuance. So as soon as you find out that they made an error, even if it's with the spelling and things like that, it doesn't necessarily guarantee that the case will disappear, but it will, at least for the time being. And at that point, if they feel like they have enough evidence to go ahead and move forward with charging the live living person under law and not fucking admiralty colorable law, then they can go ahead and try and do that, right? And then you would have to have a different form of attack at that point. So therefore, this is why the judge did what he did. The guy did not win per se, as the IRS could have corrected the defeat in the writ and brought a new suit. Me personally, I would show up with an affidavit of fucking rescission, tell them to kick rocks, and then I would ask for any balance that they feel that I owe, and I would take that and I would fucking accept that for value and stamp that and tell them to have a great fucking afternoon. You know what I'm saying? That's what I would do. So if that would work or not, who knows? Why the fuck wouldn't it? That's what I'd say. So you got to know this is a game of chess. Stop playing checkers with these motherfucking weirdos. Until I see you again.